Hi, I'm David Marchant, the founder of OffshoreAlert, which investigates participants in high-value cross-border finance with an emphasis on high-confidentiality jurisdictions. Our specialty is exposing investment fraud while it's in progress. Enjoy our content.
Hi, everyone, and welcome to our panel today, where we'll be discussing the FATCA, the first prosecution convictions of foreign bankers and service providers related to FATCA. My name is Alex Shea. I work for Guidehouse, which is an international consulting firm that helps clients with risk and compliance and regulatory matters. I personally work with lots of the offshore financial center clients, helping them with all their regulatory issues, whether it's U.S. or local regulations. I am also joined with two colleagues, David Gopstein of the U.S. Attorney's Office and Michael Levy of Mayor Brown. And I'll turn it over to David to make a brief introduction of himself.
Good morning. My name is David Gopstein. I'm an assistant U.S. attorney in the Eastern District of New York, which covers Brooklyn, Queens, Staten Island, and Long Island. I apologize, I'm currently having visual difficulties, but I'm able to connect with audio, and hopefully I'll be able to join a little bit later on. I'm a prosecutor in our business and securities fraud section, covering crimes such as securities fraud, wire fraud, money laundering, Foreign Corrupt Practice Act violations, and as relevant today, tax violations. And I'll be speaking today, not officially on behalf of the office, but in my personal capacity. Look forward to the panel.
Thank you, David. We're also joined by Michael Levy of Mayor Brown.
Hi, I'm Michael Levy. As Alex said, I'm at Mayor Brown in their Washington, D.C. office. I am a white-collar defense lawyer. Early in my career, I clerked for the United States Supreme Court. I did a White House fellowship. I was a federal prosecutor at the U.S. Attorney's Office in Washington, D.C., and for the past 20 plus years have been in private practice as a white-collar defense lawyer with a particular expertise in highly complex financial, tax, and accounting matters, many of them involving international issues ranging from Enron to the collapse of MF Global to representing one of the largest insurers in the United States in an SEC and DOJ investigation involving offshore reinsurance, and representing Deutsche Bank in Switzerland in the Swiss tax evasion matters. So a lot of experience in these areas. Looking forward to this conversation.
Thanks, Michael. And we'll move to our agenda here. So we're briefly going to go over what is FATCA. Hopefully most of the audience already has a base understanding. Then move on to FATCA prosecution. We'll actually talk about the case, and David will give us all of his insights and great value there. And then we're going to talk about what do you do if you find a FATCA problem, how you can respond to either a FATCA issue or other sort of compliance issue related to U.S. matters. And we'll talk a little bit about compliance best practices, how you can get ahead of these issues, and what lies ahead what potentially could lie ahead in the future of U.S. enforcement. So just as a high level, talking about what is FATCA, right? FATCA is a withholding and reporting tax law. It was enacted under the Obama administration. What it really does is what's really meant to do is to deter U.S. persons from committing U.S. tax evasion through intergovernmental agreements with different jurisdictions. So depending on what type of jurisdiction you are in, that information is either being shared directly to the IRS, and then also the U.S. government will also be sharing to your local jurisdiction. So depending on what type of intergovernmental agreement, that will depend on your arrangement. For persons that do not comply with FATCA FATCA, a 30% tax withholding is applied to any payments made. and they're considered recalcitrant account holders. So those are for individuals that do not comply with FATCA. And like I said, this is depends on your agreement with your local IGA, but again, that's how information is shared. And just like I said, the purpose of FATCA is, one thing to think about is that U.S. citizens are taxed on their worldwide income. This is different from other nations where they're taxed on their residential income. So that's something to think about. FATCA was enacted to combat U.S. tax evasion, like we talked about, and then FATCA primarily aims to prevent U.S. tax persons from using foreign accounts to facilitate the omission of federal tax offenses. So one thing to think about is, a lot of our clients and our clients' talk about is, they really don't even understand their own, U.S. If they're U.S. citizens or not, or have U.S. indicia of, within themselves. So, many people we know in the Caribbean or other jurisdictions actually come to the U.S. to, they're actually born in the U.S. Their parents come to the U.S. because the health system is strong. When you're born in the U.S., that gives you certain requirements to become a U.S. citizen. So understanding that part is really important. So it becomes a lot more complex than just, you either have a U.S. passport or you don't. Like I said, FATCA was under the became effective in the Obama administration in 2014. And the IRS has spent over $380 million to implement FATCA. So it's definitely something that, is here to stay and, for the long term. So with that being said, we wanted to now talk about the first FATCA prosecution, and I will turn it over to my colleague, David.
Thanks, Alex. So I was one of the prosecutors on a case that came out of the Eastern District of New York that resulted in the first 2 convictions for failing to comply with FATCA. So what I thought I would do is just talk a little bit about the allegations, the indictment that led to this FATCA criminal charge, walk through the charge itself, and then talk about the guilty pleas and the sentencing. So this is on the screen is just the press release from when those charges were announced back in 2018. And so as detailed in the indictment, back in 2014, the U.S. government was investigating a number of Belizean-based brokerage firms for stock manipulation schemes, essentially schemes to manipulate the price and trading volume of publicly traded stocks of publicly traded companies in the United States. And during that investigation, the government learned that a Belizean broker was starting to execute trades through Beaufort Securities in the United Kingdom and opening accounts there. And so in around 2016, a confidential source who was also from Belize reached out to Beaufort and put somebody at Beaufort in touch with somebody who was supposed to be purported to be a United States citizen and a very wealthy one. Now that person turned out to be an undercover agent working for the government. And so in 2016, over a number of months with phone calls, emails, and in-person meetings, the undercover agent developed a relationship with Beaufort. And the person who he spoke with at Beaufort was Peter Kiriakou, who became a defendant and ultimately one of the 2 who's pled guilty to conspiring to defraud the U.S. by failing to comply with FATCA in this case. What the undercover agent said was that, 1, he was a U.S. citizen, and 2, he was looking to open brokerage accounts at Beaufort Securities in order to further his stock manipulation scheme. And he said he needed to open a number of brokerage accounts, and one of those reasons was sort of to avoid SEC disclosure requirements. And those are requirements where if an individual or an entity owns more than 5% of a particular stock's publicly traded company, they have to make a filing with the SEC. And throughout the course of this, he discussed the brokerage accounts that he was hoping to open and the purpose of the scheme. And so as the relationship progressed and they were working towards opening accounts, Kiriakou and Beaufort agreed to open these accounts for the undercover agent. But the undercover agent's name did not appear on any of the account opening documents. Rather, the brokerage accounts were all opened in the names of Belizean brokerage accounts, the names of Belizean IBCs. And when they actually opened these accounts, there was a FATCA form to fill out. That was a Beaufort FATCA form, and it stated, the purpose of FATCA is to prevent tax evasion by U.S. citizens. And that form was completed without any reference to the undercover agent. And all of the account opening paperwork was completed without any reference to the undercover agent, who was purported to be a United States citizen, engaged in, according to him, multi-million-dollar stock manipulation schemes. And Beaufort Securities was an FFI under FATCA. And so that was in late 2016. And as that relationship developed, Peter Kiriakou introduced the undercover agent to somebody named Arvind Singh Kanai at Beaufort Management in Mauritius. And again, the undercover agent went through who he purported to be, a U.S. citizen, what he purported to do, stock manipulation schemes, and what he purported to be looking for. Well, here, it was companies through which to operate the scheme, but again, to not have his name or his identity involved. And he was able to get it. And so, again, he was able to open 6 GBCs at Beaufort Management Service in Mauritius. Again, no FATCA information was collected, and his identity was not on any of the paperwork. Relatedly, the government learned as part of that Belize investigation into stock manipulation schemes from a cooperating witness in that investigation. The government learned that that cooperating witness had been laundering the proceeds of stock manipulation schemes through Loyal Bank, which is a bank with offices in St. Vincent and the Grenadines and in Hungary. And so again, the undercover agent, purporting to be a U.S. citizen, a wealthy one involved in stock manipulation schemes, reached out to Loyal Bank and reached out to Adrian Barron, who at the time was the chief business officer of the bank. And again, they had a number of meetings and phone calls. And again, the undercover agent described who he purported to be, what he purported to be doing, stock manipulation schemes, and he said he needed bank accounts in order to process a lot of those funds. And so over the course of a number of months, the undercover agent was able to open these accounts at Loyal Bank. And again, no FATCA information was requested. Again, it was clear from the undercover agent statements that he was a U.S. citizen. At one point during the conversations, Mr. Barron said, no U.S. involvement I can see. Mr. Barron was the responsible officer for Loyal Bank under FATCA. And again, the undercover agent was able to open 6 bank accounts using the names of IBCs and Belizean nominees. And so that is essentially the background of the undercover operation that, as alleged in the indictment, led to these FATCA charges. So what does this mean to have a FATCA charge, FATCA criminal charge? And that, I think, is on the next slide. Thanks, Alex. So the charge for failing to comply with FATCA was actually brought under Title 18 United States Code, Section 371. And that is a conspiracy charge. And the Section 371 can be brought for all sorts of things. It can be brought for conspiring to defraud the United States, generally, in a variety of ways. It can also be brought for conspiring to violate another statute. So, for example, you can be charged under 18 U.S.C. 371 for conspiracy to commit securities fraud. And in fact, Peter Kiriakou was charged with that as well and pled guilty to that. And the statute requires, as charged, that the defendant knowingly and willfully conspire to defraud the United States by impeding, impairing, obstructing, and defeating the lawful governmental functions of the IRS in the ascertainment, computation, assessment, and collection of revenue. And as was in this case, specifically by failing to comply with FATCA. And I think I'll highlight the knowingly and willfully part of the statute here. And I think we can discuss that a little bit later when we're talking about the nature of these charges and how future FATCA charges or other international tax fraud charges may be brought. But that was the charge. That statute has a 5-year maximum prison sentence. And that is how the defendants were charged for FATCA violations.
Thanks, David. And, Michael, how does this, we see conspiracy here, but how does that differ from aiding and abetting?
Well, in order to have a conspiracy, the definition of conspiracy is an agreement between two people. So the way in which you prove a conspiracy differs significantly from the way you would prove aiding and abetting. But I think conceptually, this case could have also been brought under an aiding and abetting theory. That is that the defendants at Loyal Bank aided and abetted the undercover agent in attempting to evade taxes or in attempting to commit securities fraud in the case of Beaufort. So there are different ways of charging this. I think conspiracy has with it a number of evidentiary advantages in terms of what evidence the government can put in its case in chief. It also captures, I think, the nature of this particular scheme a little bit more directly, because obviously there was a connection among all of these people in terms of getting together to assist the conduct at issue. But for example, in the Swiss tax evasion cases where you had banks in Switzerland being accused by the Department of Justice of aiding and abetting the evasion of taxes by U.S. taxpayers, that doesn't have the requirement of proving an agreement between the taxpayer and, for example, the bank. And so aiding and abetting seem to capture that conduct a little bit more directly. But both are theories that I think the government could legitimately use in a case like this.
Thanks, Michael. So I guess, David, we can now move to the FATCA convictions, unless you had anything else, and talk about what was actually the actual results.
Yeah, no, thank you. And I agree with Michael. There's a lot of different ways that these kind of cases, I mean, you can talk about FATCA, but really any of these kind of fraud, different theories under which you can charge a tax fraud or other fraud cases, when there's a number of parties involved. And they have different requirements. So, I mean, for example, in the 371 statute, in any 371 case, what you have to prove is first the agreement, then that somebody also, they call it an overt act, somebody took some step in furtherance of the agreement. So those are the requirements there. And also when you charge under different theories, sometimes there's different statutory maxes. So as I mentioned, there's the 5-year statutory max for 371, but some other statutes have higher statutory maxes. And also some offenses have a conspiracy count within it. So for example, money laundering, which Kenai at Beaufort Management pled guilty to. He pled guilty to a money laundering conspiracy. That statute has a conspiracy charge within it. So you don't need to charge 371. And that has a 20-year statutory max as compared to the 5-year for 371. Turning to the FATCA convictions, Adrian Barron, who, as I mentioned, was the former chief business officer at Loyal Bank, he pled guilty to this FATCA charge in violation of 371. It was a conspiracy to defraud the United States by failing to comply with FATCA. And then Peter Kyriakou, who was the former investment manager at Beaufort Securities, he also pled guilty to that count, conspiracies to defraud the United States by failing to comply with FATCA. In addition, he pled guilty to a separate count of conspiracy to commit securities fraud in violation of the same statute, 18 U.S.C. 371. Barron was sentenced to time served, which at that time was a little bit under a year in prison, and was also issued a fine. Peter Kyriakou was sentenced to 3 years probation and a fine as well. And so those are the two FATCA convictions. And yeah, I think maybe I'll turn it back to Alex.
Thank you so much. Appreciate that, giving that background. So, if you could talk to us a little bit about, David, like I see a lot of different offshore financial centers mentioned here. It looks like it was a very, complex, operation. Talk to me a little bit about, how do you tie these different locations together and all these different, entities? Like, what is the process for, for bringing this case, and for our audience out there that probably have very complex offshore, maybe work for companies or financial institutions that have lots of different locations in these offshore financial centers. What should we be thinking about?
Yeah, well, I would say that generally speaking, cases that involve complex frauds, and in particular international frauds, they take a long time to develop and they're hard to uncover. Fraud in general is hard to uncover, and then fraud at an international level is harder to uncover, and then fraud that's that in some ways depends on disclosure requirements and things like this are particularly hard to uncover. So, if you look at what's set forth in the indictment in this case, it started with an investigation and information learned back in 2014, and it developed over a number of years, with one piece of information leading to another, and one entity leading to another. And so, as a general matter, I think in these kind of cases, investigators and prosecutors sort of follow the evidence and hope to build a case in that way, or at least see where the evidence leads. Sometimes that lead stays within a jurisdiction, but in other cases, especially in today's world, it takes you across the world, across the globe. And I think the other thing that I would say is that you see, oftentimes you'll see different kinds of offenses all ultimately coming into one investigation. And so, this wasn't just a FATCA case or just a FATCA investigation. It was, it started as an investigation into securities fraud schemes that were using offshore brokerage firms to manipulate publicly traded stocks in the United States. But ultimately, there was securities fraud, and there was money laundering charges, and there was the FATCA. And so I think you see, and I think it's not unusual to see multiple different kinds of offenses and schemes sort of combining into one, especially as an investigation develops over time, over a number of years.
Thanks, David. And just as a follow-up, what type of people, lots of times criminals think, like you're saying, I'm not in the U.S., I don't have to worry about these things, right? I can violate U.S. laws and not be, because I'm not in the U.S., I don't really have to worry about it. Not specific to this case, but what type of tools do you have at your disposal to work with local counsel or local regulators and enforcement to try to cooperation with local jurisdictions?
Yeah, absolutely. I mean, it's important, and it happens. It happens through mutual legal assistance treaties, which are treaties that the United States has with other countries to help with law enforcement. And those are important tools for developing international cases. And so you see, in all sorts of different contexts, if you are committing criminal conduct, the fact that you're not located in the United States, but you are violating criminal laws in the United States, it doesn't mean that you're immune from prosecution. It may take a while, and obviously sometimes it's difficult to uncover, but it doesn't mean you're immune. And you can see through a number of examples of the U.S. government working together with other governments and regulators as well.
Great, thank you so much. And now I want to turn it over to Michael, who can talk a little bit about what you should do if bad conduct is found, not related to not only to FATCA, but just your general white collar issues.
Yeah, thanks, Alex. Before I do that, I actually just want to emphasize something that David just said, which is that both with and without international cooperation, and there is more and more international law enforcement cooperation every year, it's very clear that the United States for quite some time has been aggressively seeking out and investigating offenses of violations of the United States law that occur overseas. A number of my clients are foreign citizens, not even citizens of the United States, haven't even necessarily even been to the United States. And yet, sort of like U.S. tax law applies all over the world. U.S. criminal law applies all over the world, and there are plenty of statutes, not just tax statutes, but Foreign Corrupt Practices Act and all kinds of other things that apply internationally. And this particular case, and David would know better than I don't think anything he just described actually involved international cooperation with foreign law enforcement. It was an undercover agent of the FBI who was engaged in all of this and made the case. The second observation from what he said that I think is relevant to the people at this conference is it's important to look at the Barron case, the Loyal Bank case, whatever you want to call it, sort of from two different perspectives. On the one hand, it's important to note, as David said, it's not like the United States Department of Justice decided to go out one day and bring a FATCA prosecution on a criminal basis. This did not start as a FATCA prosecution. That wasn't the focus at the beginning. And so people shouldn't be thinking, oh, the Department of Justice is targeting people who are opening up bank accounts and trying to determine whether or not people were born in the United States or not born in the United States and things like that. That's all very important, but that's not the focus and the target of what the DOJ was doing here. On the other hand, what David said is incredibly important. They were looking at something else, and they wound up going into the question of money laundering and FATCA violations. And they were more than happy to use what otherwise would be seen as very aggressive investigatory tools, an undercover agent, in order to pursue that. And so I think it's important to recognize that although the government may not be looking to make FATCA cases, they are more than happy to make FATCA cases when their investigations lead them there. And it's a very powerful and effective tool. So I don't think it diminishes at all the importance of compliance with FATCA and a recognition that the Department of Justice is going to go there if they have to. So sorry for that digression. In terms of what you should do if bad conduct is found, and I sort of say not necessarily just bad conduct, but just sometimes it's just mistakes. Sometimes it's just a breakdown in a process. I think the first and most important thing to do is to hire outside counsel to conduct an internal investigation. And yes, that is somewhat self-serving as an outside lawyer, but I can explain why that's so important. And it's really both the idea of outside and counsel. You want an independent third party to take a look at what happened. If you do your own investigation and somewhere along the line, the Department of Justice wants to know what happened here, they are not going to give the same credibility to your findings that there was no wrongdoing as they would to the findings of an independent law firm that there was no wrongdoing. Or if there is wrongdoing, you really do want to find it. And so hiring experts who are experienced in this area will be incredibly helpful in really getting to the heart of what happened and why it happened and who did it in a way that outside lawyers who are in this area are trained to do, along with consultants and forensic experts who they hire to work with them. The second and really important thing about hiring outside counsel is that means that the investigation that outside counsel performs is protected by the U.S. attorney-client privilege and the attorney work product doctrine. And that means that depending on what it is that you find, the company may decide that it does not want to disclose that information. There may be civil liability concerns. There may be all kinds of things. It gives the bank, the company, whoever it is, the ability to decide once the investigation is over whether or not to disclose it, and even if the Department of Justice investigates, to still maintain the confidentiality of that privileged investigation. It means, in part, that hopefully people at the company will be more forthcoming and more open in talking to the company's lawyers in conducting that internal investigation than they might otherwise be. And the Supreme Court long ago in a case called Upjohn recognized that corporate attorney-client privilege is incredibly important in order to let the lawyers do their job, get to the truth, and that wouldn't necessarily happen if the attorney-client privilege didn't protect those investigations and the information that was found would just be willy-nilly handed over to anybody who asked for it, whether they be plaintiffs, lawyers, or the government. The second thing is, once you've completed this internal investigation, and it's part and parcel of the entire context, I think one way I think about this is, it's important to take this seriously. So launch an internal investigation with outside counsel, and then depending on what it is that you find, take what you find seriously and do something about it. So if you've identified a problem, and the problem could be no affirmative wrongdoing, simply a breakdown in process, or simply a process that wasn't well designed. If you find that, fix it. Fix it right away, and fix it in a way that you're convinced will be done properly going forward. If it's actually affirmative misconduct by somebody, take disciplinary action. Fire that person if you need to. Make sure that you are sending a message of deterrent to everybody else at the bank or the company to say, hey, wait a second, this is not okay. And if you do this, you will suffer the consequences of that. That's not who we are as a company. And if you either disclose this to the government or the government finds out about it and comes to you, you can say, we did the right thing here. We found out what the problem was and we dealt with it. In terms of dealing with the problem, I think it's really important to keep in mind that you can't just look at the small little piece where this particular situation occurred, solve that, and then say everything's fine. On the other hand, you don't need to look all over the company, anywhere you could possibly find, to see if any bad conduct happened. I don't think anybody reasonably expects that. I've always thought that the key was to think about this as almost like a cell on a spreadsheet, where you have to do all of the everything in that row and everything in that column in order to find out what happened. So if you have one kind of a problem in one particular area, find out whether or not that same problem or a similar problem is occurring in other places within the company. And then also find out whether other problems are occurring in that same part of the company. If you handle all those, look at all of those, identify any problems in those two ways and deal with them, I think you'll be able to present to the government, if they come for you or if you disclose to them, that you've done the right thing, you've looked seriously at it, and again, you've taken it seriously. So the next question, after you've dealt with the problem, is whether or not you should disclose this to either the Department of Justice, local authorities, or both. And that kind of analysis is very much guided, at least on the US side, by what are referred to as the principles of federal prosecution of business organizations, which are 11 factors set forth in the Justice Manual, which governs the conduct of Justice Department prosecutors. And those 11 factors are designed to give some structure to a decision by the Department of Justice whether or not to take action against a corporate entity, whether or not to, if they do charge, how significantly or severely to charge. Do they enter into a deferred prosecution agreement or a non-prosecution agreement if they do go forward, things like that. And what's important to think about in terms of those principles, and I'm not going to get into all of them, we don't have that much time, is several of them are baked in to whatever conduct already occurred. Essentially, the nature and seriousness of the offense already happened. How pervasive that conduct was within the organization already happened. Whether or not the organization had previously been involved in similar types of misconduct has already happened. But then there are several factors that come into play in terms of what the company can do once it finds that out. And so when you start to look at things like the extent to which the company is willing to cooperate in the investigation, that obviously is furthered by how you interact and deal with the Department of Justice. And I'm sure David can talk extensively about that if you'd like. One element is the state of your compliance program. And the principles were actually expanded. It used to be that only the state of your compliance program at the time the offense occurred would be considered. But they've added the idea that now they'll also look at the state of your compliance program at the time the decision's being made about whether or not to go forward. And so it gives you an opportunity to improve your compliance plan and improve your compliance program, as we sort of discussed in terms of taking it seriously. And that can be a positive factor arguing against prosecution of the company. There's also the question of remedial actions. So again, if you found that somebody engaged in misconduct, it's going to be important to discipline them, and discipline them in a way that sends the message that this is serious conduct, including potentially terminating them, depending on the nature of the conduct. You need to take it seriously enough so everyone else at the company knows this is not condoned, it's not okay, and if it happens, serious things will happen to you. And then finally, whether or not you self-report, whether or not you go forward to the government. Obviously, if you do come forward, that is a significant factor in favor of leniency against the company. On the other hand, what you need to weigh is this something that we've dealt with internally in a sufficient way? We don't think that the Justice Department's likely to learn of it. And if they do learn of it, we have a credible means of going to them and saying, yes, we recognize that this happened, but we hired an outside law firm. We found out what happened. We dealt with it. We have a great program going forward, and it's not going to happen again. That's what you want companies to do. So, you don't have a basis to come with an indictment of our company for this. That's obviously an easier argument to make if the issues are failing to catch places of birth on foreign, non-U.S. passports and recognize that those are U.S. persons, as long as you fix it and fix it moving forward, versus an undercover officer coming in and telling you, I am a U.S. person, I want to engage in securities fraud, and I want to hide that fact and evade taxes at the same time by using your bank. Clearly, if you find that, you're gonna have to self-disclose, for fear that if the government were to find out about it, which they would if you don't know it's an undercover agent, they do, for fear that if they find out about it, say it's not an undercover agent, that it's going to be a very, very serious consequence to you and potentially threaten the existence of your institution. So hopefully that helps at a broad level how I would think about advising a client if they find out about some wrongdoing with respect to FATCA or just about any other offense.
So Michael, thank you so much. That was a lot of valuable advice there for our clients or potential financial institutions out there. Mike, as a follow-up to that, David, when, like Michael outlined just now, the self-disclosure, full, cooperation, and then remediation lines, did you take any of that into account in this case for either the individuals or the corporations? Are there any pros and cons to the things that they did that helped or hurt them?
Sorry, Alex, that was for me, I assume.
Yes, David, sorry.
Yeah, no, I mean, in this case was charged via indictment and an undercover op. So charges were publicly announced when the indictment was unsealed. But I would say on some of Michael's comments, which I think are really helpful on the bigger picture about corporate investigations and disclosures, and then also the distinction you drew at the end about failing to find somebody's birth site versus an undercover telling you I'm a U.S. citizen. If you look at a lot of the corporate resolutions that the department has entered into recently, regardless of the criminal context, I think you'll see an analysis and it's sort of a careful weighing of a lot of these factors that Michael just went through, and they impact how a particular case is viewed. Everything ends up, it always ends up being fact specific, but in terms of voluntary disclosure, and that's one of the 11 factors. There's also different ways of looking at voluntary disclosure. There's different ways of looking at cooperation credit. You can get full cooperation credit. You can get partial cooperation credit, depending on what you as an entity do. And so, if you have a case where you were sort of slow to provide documents, or you provided some, but you didn't want to make witnesses available, or you made some things available, that may be viewed as partial cooperation, but not full. And I think that you can see that spelled out in a lot of the resolutions, the corporate resolutions that have been reached, whether they be guilty pleas, deferred prosecution agreements, non-prosecution agreements. And I would just add on Michael's point at the end in terms of the finding out that somebody didn't find that one individual may have had a U.S. birthright. And I would just go back to what I said before in terms of the requirements for a criminal violation. And those are the requirements that were charged under 371. But it doesn't really matter what statute you're talking about, because U.S. criminal statutes have criminal intent, fraud statutes have criminal intent requirements. And in order to be convicted, there has to be a criminal intent. And that I think that's something that should apply to applies broadly, but it applies to what Michael was speaking to as well.
Yeah, although obviously, as more and more people throughout the world get more and more familiar with U.S. citizenship being, taxed on their income worldwide, with birthright citizenship in the United States, at some point, even what would have been previously thought of as mistakes wind up becoming knowing and willful conduct once it becomes so well known. And I think in this area, we're heading in that direction. I think, David, there's also an interesting piece of the cooperation thing, as you discussed, when it comes to complex statutory and regulatory requirements in other countries that may prohibit someone from providing information, for example, documents to U.S. authorities for bank secrecy or privacy or other reasons. And oftentimes, what the financial institution may want to do and what it's allowed to do by local law may be two very, very different things. And how as a defense lawyer and a prosecutor you communicate on those things, it oftentimes has a very significant impact on the way the prosecutor will view the financial institution's level of cooperation, and trying to find creative ways to convey substance without violating foreign countries' laws with respect to data protection and other things is increasingly a very important part of my job and your job.
Totally agree. We see that come up all the time, and it's always a different variation of the same issue, but it comes up in nearly every international investigation, financial investigation.
And just kind of going further on that, this case, like you started out talking about, David, was from 2014. What sort of timeline and limitations does the U.S. government have when bringing these actions? What type of people may think, a couple of years go on, nobody's gonna. If I haven't been caught now, then I'm fine. I'm in the clear. But what is the timeline there from when you can actually still enforce some of these actions?
Sure. So the answer is it depends on the statute, but a lot of statutes have a 5-year statute of limitation. So that's 5 years from the conduct, or in the case of a conspiracy, 5 years from the end of a conspiracy. There's some statutes that have 10-year statute of limitations. And those are, for example, if you have wire fraud affecting a financial institution, that'll be a 10-year statute of limitation. And again, that's from end of the 10 years from the conduct, or in the case of a conspiracy, the end of the conspiracy. The other thing I would add, though, is that, and I think it's particularly relevant to these international investigations and cases, is that the statute of limitation, the government can make an application to a court to toll the statute of limitations for up to 3 years, as it makes, and I talked about these MLATs earlier, these mutual legal assistance treaties, pursuant to a treaty with another country, the U.S. government can make a formal request for assistance in an investigation. So, for example, the government is investigating a group of bankers in a particular country, or a group of individuals in a particular country, and they need certain bank records from a bank in that country. They can make an MLAT request to that country. Oftentimes, it can take a while to get the records. Depends on what's being asked. And so there's a statute that if a judge grants this order, up to 3 years can be told. Now, I think that if the MLAT is fulfilled, then the tolling of the clock stops. But in short, it's generally at least 5 years, but it can be for a variety of reasons a bit longer.
Alex, just to add on to that, some tax offenses actually have a 6-year statute of limitations, and what David said, but I think warrants emphasis, is for conspiracy offenses, it's 5 years from the end of the conspiracy, and conspiracies are rarely found as a matter of law to have ended. So they are typically ongoing because oftentimes the government can charge that part of the conspiracy is hiding the offenses that occurred. And as long as people have not affirmatively disavowed the conspiracy, essentially said to their fellow co-conspirators, I hereby withdraw from this criminal conspiracy, which, as you might imagine, doesn't happen very often. Conspiracies can go on for many, many, many years. And then you have 5 years after the end of the conspiracy within which to bring charges under 371. And so I think anyone who thinks they're in the clear for any of these offenses really needs to recognize that although I have had statute of limitations throw out charges in one of my cases, and that was very significant, it's not typically going to be very successful from a defense perspective.
So just as a hypothetical, if say in 2005, a relationship manager opened an account for a U.S. person and hid their U.S. citizenship, and the bank got together and another securities company similar to this in 2005, and the account stayed open, right? And that account is still trading and being active to this day. The clock. Has it stopped, or is it still going in that situation?
Tick tock, tick tock, tick tock. It's still going.
Okay. Yeah. So just want to be clear that even if it wasn't on your watch, right? But if it's still going on, if that account's still open, you're still going to be liable for those actions, even if it was prior to 10 years ago.
Right, because the offense is ongoing, right? The offense is still, at least in theory, a conspiracy to evade FATCA. And so as long as the evasion of FATCA is continuing, the offense is continuing.
Right. Thank you so much. And kind of segueing into that, is talking about some of those compliance best practices, like David and Michael talked about, what are some of the deterring factors or beneficial things that you can do to help your organization, and having strong best practices, including policies and procedures that address FATCA and their requirements. Having that, the fact that your corporation or firm has that is going to be really powerful, even if there is an issue, right? To say that there was a tone at the top, this was considered from the beginning. FATCA is really, when you think about it, it's really enhanced due diligence or a know your customer issue, right? So, understanding your client base and having a really strong KYC or EDD program is going to be, really is going to be the pillar of which you're going to, kind of prop up your FATCA program. So making sure that you understand, your client base and have the proper tools is going to be imperative. Things that we've seen through FATCA that KYC, a lot of banks and financial institutions have gone and updated their files, their client files, to make sure that they are being compliant with FATCA and other, like CRS as well. Things that weren't considered before were like dual citizenship. Person would, use the citizenship that was most beneficial to them to, hide who, where their tax liabilities were. So that's something that's really you should be thinking about when you are doing your updates. And then also making sure that you are complying with reporting with your relevant IGA. There's different ways in which you're reporting information. Sometimes it's directly to the IRS. Other times it's through your local regulator. It depends on your arrangement. And then from a compliance standpoint, educating your staff. Relationship managers, front office people often don't understand, some of those requirements that they have to comply with, that your compliance people may have, but your front office doesn't have. So when they're dealing with clients and onboarding clients, or even, having interaction with their normal clients that they've had for maybe many years, it's important to think about some of the things that may be tipping you off that there's something going on where they're trying to hide their U.S. citizenship. I mean, many times clients will not tell you that they're U.S. citizens, and they're trying to purposely come to you to hide that fact, and so they're not going to disclose that to you. So you have to be on the lookout for things. FATCA for individuals has a $50,000 US dollar reporting requirement. So some individuals may, if they are US persons, try to stay just under that reporting threshold. Also, we've seen a lot of people convert, dollars, fiat, into commodities such as gold and keep them in, local safety deposit boxes. That's something to also kind of just follow up on. Now, with more and more use of cryptocurrencies, your individuals are able to mask that source of income, whether it's coming from U.S. persons, and if it's going to an account that's being, maintained as on paper as being non-U.S., but it's really just a U.S. person using that as I guess a dummy account, is something to think about. That goes with the common straw beneficial ownerships to hide your true ownership through nominee shareholders, other sorts of ways in which they'll try to hide, that the U.S. person is actually the beneficial owner in reality rather than on paper. And then again, the last one is, overly complex structures to conceal true beneficial owners. We often see very complex trust structures or corporate formations within corporations, that when you actually dig down into them, you find that they are actually U.S. persons. All of these things are not themselves, violations or, actual proven U.S. Tax evasion, but they're red flags that need further follow up on through, additional requests to the client and remedial efforts. So with that being said, we want to talk a little bit about what the future will lie for not only FATCA enforcement, but maybe your thoughts about DOJ, where they're going as far as white collar crime and how that could affect you. Lots of times people, we've talked about how the DOJ, all this information that they've gathered over the years. So all the FATCA reporting, right? So all those foreign financial institutions that are reporting U.S. persons, they're checking that to see if U.S. persons have reported those accounts. There's an FBAR form that U.S. persons file to see if those have been reported priorly. Like Michael said, the Swiss bank program was a kind of a treasure trove of information of U.S. persons that were not disclosing funds in the accounts over there. Lots of people sent their money from those Swiss bank accounts all over the world. And they are definitely following the money. The IRS voluntary disclosure program, there people disclose not only their own bank accounts, but also part of that was providing information on what banks they used, what relationship managers they spoke with, who were the people right at these different banks that were using, that they were contacting with. So it wasn't just for that individual reporting. It was also who were some of the, also people involved in them, not disclosing that U.S. income. And then also, FinCEN, the U.S. suspicious activity reports where they are reporting, unusual behavior, whether it's between, offshore companies, what they would consider to be shell company, they call shell companies, trust structures where there's no beneficial ownership identified or business rationale for those transactions. Other areas too, like we talked about, the Panama Papers, John Doe summonses, things like that have all been collected by the DOJ, and they are now using and have been using even more frequently advanced technology tools that will connect a lot of those dots and links that wouldn't be prevalent by just looking at different data sets through an investigator. So they're using advanced analytics to link some of those connections and identify anomalies with U.S. people not reporting reporting income. And that's the same thing with not only fiat transactions but also cryptocurrency transactions. If you look at some of the recent DOJ enforcement recently, especially involving IRS, you'll see recently there were a couple very high net worth U.S. individuals that had a tax evasion scheme that was brought to light that had been going on for many years. And then also, even with cryptocurrency, they've been able to identify, darknet, criminal enterprises, whether related to evading, hiding assets, or even things like, child pornography, identifying people that were paying, through cryptocurrency. So they're really, making big steps as far as their enforcement actions are concerned. But like David and Michael have said, some of these things take time to build, but I would assume that they are all working on these cases, especially the high net dollar value cases. And that being said, with the new administration, I know that Michael and David probably have some very valuable thoughts on where we could be headed. So maybe I'll let Michael start there.
Yeah, sure. Yeah. Since David still works for the Department of Justice, maybe it's easier for me to start and he can comment. The last 4 years have been fairly strange from a white-collar enforcement perspective, which is simply to say that traditionally, in my experience, white-collar enforcement is most aggressive in Democratic administrations and less so in is more so in Republican administrations, less so in Democratic administrations, because Democrats need to prove that they're tough on white-collar crime, and Republicans need to prove they're tough on white-collar crime. Democrats need to prove they're tough on street crime. That was sort of flipped for the past 4 years. I expect that the paradigm shift is probably going to continue. I would expect that the Biden administration is going to be more aggressive. Clearly, even in the Trump administration, folks like David aggressively prosecuted money laundering matters and sanctions matters and a few other things. But certainly, notwithstanding some of the high net worth individual cases you just discussed, prosecution on the tax side has been pretty restrained compared to the way it was under President Obama. You haven't seen anything like the equivalent of the DOJ Swiss bank program. You haven't seen the government really use that treasure trove of data that you discussed, Alex, to really go against financial institutions or others. And I expect, particularly as issues of income inequality expand and become so politically potent right now, that there will be more of an emphasis on that going forward. And without making any political comments, I will note that there is a program later this afternoon on the president's tax returns, legal or illegal. So maybe that has something to do with it, and maybe it doesn't.
Yeah, I would just add that, as I said before, these cases really do take a lot of time, and for all the reasons I said before, but also because sometimes when you get a treasure trove of information, there's a lot of time to go through it and then develop your case. So the combination of the nature of the cases and the ability to have a statute of limitations or a period of time to look through them sometimes means that when you see these kind of cases, you see charges brought for conduct that actually occurred 4, 5, 6, 7, 8 years ago. But that said, for FATCA, for example, I don't expect that you're going to see FATCA cases the way you would see, a domestic tax evasion case for your local tax preparer in New York, at least in terms of volume, because it's just, for all these reasons, the time and the effort and the ability to detect this kind of fraud is just a lot greater. And that's why the deterrent value in these kind of cases is particularly something that is particularly important. These cases can be brought. They now have been brought. And that's a message that the deterrent message is one that has some emphasis.
I appreciate all those thoughts. I know I'm seeing that we are right at time, though. I'm not sure if we have time for questions, but if you do have a question, we'd love to hear it now. I believe you have a way to send a message to our organizer to send to us. So if you do have a question, we'd love to hear it. But if we are over time, please, David, let us know.
Yeah, Alex, it looks like it's about to cut off. So I just want to say thank you all very much.
Thank you all very much. And if you do have any questions, please feel free to reach out to Michael or myself, and we'd love to follow up with you.
Thanks for watching. Consider subscribing to our investigative news and documents service and attending our events. For more information, visit offshorealert.com.